it's amazing how few technical problems we've had these last 3 years when we've been doing this, but we still get them. So anyway, we appreciate your patience.
Understood. Understood.
And you are up, Mr. Baca.
Thank you. Good morning. George Baca with Baca Law Group, representing the petitioner's former wife, Emily Harrington. We're here today asking the court to reverse a judgment based on involuntary dismissal and request a remand for a hearing on the merits in this child support matter. I'd like to reserve 5 minutes for rebuttal, please.
Sure.
I don't think there's too much disagreement about the procedure or the facts, but in just a quick summary, there was a final judgment of dissolution entered between Ms. Harrington and Mr. Kemp in October of 2015. It incorporated a settlement agreement where, based upon the parties' circumstances at that time, did not include any provisions for child support. 3.5 years later, I guess, in November of 2018, the circumstances had changed, and Ms. Harrington petitions the court seeking child support, indicating in the petition that there's been a substantial change of the parties' circumstances. In February of 2021, there was a hearing on the husband's updated motion for summary judgment, which the court denies. But at that hearing, counsel for the former husband requests that the issue of needs be bifurcated from the rest of the issues to be considered by the court in the child support hearing.
And Mr. Baca, correct me if I'm wrong, but as I read the modification petitions, and I think it got to the second amended.
Yes, Your Honor.
The allegation was not that the children's needs had increased, correct? The allegation was that the Ms. Harrington's income had been reduced significantly and Mr. Kemp's had been increased, correct?
Correct.
And that was the change of circumstance alleged.
Correct.
Do we understand why there was this separate hearing about the children's needs?
I assume
because I have not been able to figure that out looking at the briefs.
The only thing I can tell you, Your Honor, is I assume that because the statute requires the court to look at those issues, that's what the parties did.
But okay. Kind of an odd procedure,
to say the least, and very odd in terms of oral motions, oral orders, and rulings. But they agree to have this hearing solely upon the children's needs. And that occurs on November 17th of 2021, after Ms. Harrington presents both testimony of herself, her former husband, and extensive documentary evidence in which Ms. Harrington put together a spreadsheet of the things that her daughter needed, or daughters, excuse me. She had 2 daughters, still does, but has 2 daughters that she documented in excess of $200,000 worth of need. At the end of that hearing, counsel for the husband indicated that judgment should be entered, or there should be an involuntary dismissal because the former wife did not present evidence of needs plus something else, and that plus something else was a change in circumstances. The trial court agreed with that and dismissed the petition.
And did I also, in all fairness, often at these hearings, the discussion kind of swings this way and that, but I read something about there was no, an indication that there was no proof of an increase in their needs. Is that something that judge seemed to be concerned with?
There was, I don't know if it was an increase in their needs or a change in their needs, but the bottom line was there was some additional evidence beyond establishing what the children's needs were that had not been provided to the court, which formed the basis of the court's ruling.
And your assertion is that the hearing was not called for anything other than the needs of the children.
Correct. Absolutely. That's precisely our argument. And we've cited the court to the due process case law on this issue about the scope of the hearing, given proper notice. And it's quite clear, regardless of whether the judge was correct or incorrect in terms of the need to consider the children's needs, that was the sole topic of this hearing. It had been confirmed multiple times prior to this hearing. It was confirmed during this hearing. And the only time the court rejected that notion was at the time that counsel for the husband moved for involuntary dismissal. Thereafter, the court rejected it again when it denied the motion for rehearing without a hearing. But, you know, I've been doing this a long time. I know you all a long time. Back in my day, they used to call this either an ambush or sandbag, where somebody goes in, you're told that it's going to be about one topic and one topic only, something else comes up, and then you lose based upon the something else. That's what happened in this case, and Ms. Harrington did not get a hearing, a fair hearing, even remotely, concerning the child support petition that had been filed. The second part of our argument is, even if this petition was based solely upon the substantial change in circumstances of Mr. Kemp, okay, we did present in the petition Ms. Harrington's substantial change in circumstances with her finances going down, Mr. Kemp's finances rocketing up. He's a very successful businessman. Ms. Harrington and Mr. Kemp went to school together. Their fortunes just changed, and it proved that, at least for right now, he's a little bit more successful businessman than she is. But the bottom line is his income changed dramatically, and the judge did not even consider this evidence at all.
Well, and let me, vis-a-vis your first point, there was, I know in this hearing there was discussion about, you know, she's making less, he's making more, but there wasn't really an evidentiary hearing on that, was there?
No, in fact, anytime that Ms. Harrington's counsel even asked Mr. Kemp about that, he got shut down by the court.
Right. So yeah, and okay.
So even to the extent, I mean, the judge would not allow Ms. Harrington to present that evidence, and we've cited the court to the Miller case, to, I believe, every single DCA, now with the exception of the 6th, because they haven't had an opportunity, to the best of my knowledge, to rule on it, has held that a substantial change in circumstances, that is, for the paying spouse, that is, somebody whose income has changed northward dramatically, that in and of itself, if that was the only factor, would be sufficient to justify a modification. Now,
let me ask you then about, you know, the other side, and I know Ms. Maxwell is raring to go with Taylor, the Taylor case.
Right.
And how do you square that with this situation?
Easy. The judge in the Taylor case conducted an evidentiary hearing in which he considered all of the circumstances. He then issued a written, reasoned decision, weighing all the statutory factors and ultimately exercising his discretion to determine that an increase would not be supportable under the circumstances in that case. I'm not saying that on remand, if the evidence is presented, all of the evidence, and it's all considered by the trial judge under the statutory factors the way it's supposed to. I am not going to say that if there's not an award of child support, that it would necessarily, as a matter of fact, be an abuse of discretion. I think what we are really requesting here is just a fair hearing and an opportunity to have all of those factors that are considered in making these decisions considered. And that's what she didn't get. And that's what she's entitled to under the law. That's the reason why we're before the court. I recognize that that one factor does not necessarily mean you get an increase in child support, but that one factor does determine that if that's the only thing that the court focuses on after it balances all the other things, that one factor in and of itself would be sufficient to justify a modification. That's what the Supreme Court said in Miller. It's what the third DCA said as recently as 2020, I believe, in Gore. And that's what we're asking the court to have is, let's have a hearing, consider all of the evidence, and then give us a written order, okay, in which you give us your reasons, you cite the facts, you cite the law, and give us an opportunity at some meaningful appellate review, not we're going to go and we're going to dismiss your case because you didn't put on evidence that I told you didn't need to put on at this hearing. So unless the court has some further questions for me, I just, Taylor says the court has discretion. I agree with that. I don't challenge that. But where the discretion is not, in this case, it was never exercised. It's more like the situation where the judge has made an error of law, and this court can look at it in that terms, because there's not been a deferential decision that's been made by the trial court in this case, based upon a reasoned judgment of all the evidence that should have been presented. So unless the court has some additional question for me, I'll give the floor to my opponent.
Okay. Thank you, Mr. Baca.
Thank you.
Ms. Maxwell.
Good morning. May it please the court. Kim Maxwell of Boulder, Lundy, Koch, and Martino on behalf of the appellee Jack Kemp. With regard to the issue of due process and notice, I think the record really couldn't be more clear as to the scope of the hearing that occurred in November of 2021. The record from the summary judgment hearing and the transcript reflects both parties through counsel consent and understanding of the scope of the November 2021 hearing. And I think the court was clear by saying we need to first understand whether the needs of the children have changed or increased, and the chips will, I think the court used the words, the chips will fall thereafter.
Well, and that's what, frankly, Ms. Maxwell, I was kind of confused by that, because the allegations of the petition were not that the children's needs had changed. The allegations of the petition is that the parties' income had diverged significantly, and the original agreement had said because the parties' assets and incomes are the same and they're going to spend equal time sharing, there will be no child support. And this petition was saying, well, that had changed. So I don't understand why the court was so focused on the question of whether the children's needs had changed as a separate issue.
And I can answer that question, Your Honor. This case is unique. It's not the run-of-the-mill child support W-2 income parties where, perhaps they earn $50,000 to $150,000, where we would be following guideline child support.
Well, the guidelines actually do provide for that sort of thing, do they not? They have a provision in them that says, and I think it's sub 6130 sub, you'll get my powers of recollection here. 6130 sub 6 sub B says that if the combined net income exceeds the chart, it's I think it's 7.5% of the amount over the chart for two kids. And again, that's going to be a lot more money than they need, I think, from this case. But even so, there's a way to measure it in the guidelines. And at this point, Ms. Harrington's getting zero.
Well, that's actually not accurate, because the former husband is paying indirectly a substantial amount for the children. So I agree that zero is accurate in that he's not paying her a monthly child support payment, but he's reimbursing her for essentially everything other than food in her home.
So, but we don't know all of that, correct? Because there was no evidentiary hearing beyond what the children's needs were.
No, the transcript does reflect the payments that the former husband is making, for example, Berkeley, private school tuition, all of the uniforms, health insurance, every uncovered medical expense, even if it's incurred by the former wife, she's getting reimbursed for that. He pays for plane trips for the former wife's time sharing, vacations. He doesn't pay for everything she asks for because some of those requests are unreasonable and the record. And
Well, I don't know. I don't know. When you're characterizing what her, some of her requests are unreasonable. The judge didn't find that.
No, there was, I'm just saying that there was testimony about some things that she requested that he had not reimbursed her for. And one of them, I believe, was a trip to Washington, D.C. to see somebody or obtain some sort of award or Medal of Honor.
Right.
But there was substantial testimony and evidence regarding what he does pay. And there were actually mid-trial stipulations that he would continue to pay those expenses. And in the event she felt as though something, she incurred an expense that was not reimbursed historically, that he would reimburse her for that in the event she provided him with a receipt.
But how about the suggestion, though, that she needs to furnish the children, a place to stay when they're with her that's commensurate with, the kind of lifestyle that they're entitled to given the incomes of these parties. That part seems to be left out because the judge never got to the basis of the modification petition.
I mean, the former wife's spreadsheets about what the children need included household items, not just things specific to the children themselves,
Right.
but included
roof
over their head and all kinds of things, even down to suitcases.
Correct. But the evidentiary hearing didn't get to the disparity in the parties' incomes that did not exist at the time of the final judgment.
I agree with that characterization, Your Honor. The reason why, and getting back to your initial question, why the needs of the children were addressed prior to addressing any income is when we are in a situation where the facts are a good fortune type case, we don't need to address the income if the income has increased and the child support guideline number may increase, but that's going to be beyond the children's expenses and their needs, and there hasn't been a change to their needs since the final judgment. It doesn't matter what.
But you will concede, will you not, that at least the allegation here is that there has been a substantial change in the basis for the parties' agreement that no child support would be paid one to the other. That is, that they were in an equal position financially. Correct?
Correct. Yes.
And that's the allegation that was in the petitions.
Correct.
But that has not been addressed at all by the judge in this case because there's no hearing on that.
There doesn't need to be a hearing on that issue because if Mr. Kemp's income had tripled or even 10x from final judgment timeframe, and Ms. Harrington was earning $0, and the child support guideline number would change from the time of the final judgment to now. If that guideline number exceeds the needs of the children, which it often does in good fortune type cases, then that income analysis and the child support guideline number becomes irrelevant because
I wouldn't necessarily say that's the case. I mean, we can debate that philosophically, but what happens generally in child support is the court orders one side to pay child support to the other party pursuant to the guidelines. And here, what you're suggesting is so long as Mr. Kemp is willing to pay for things, no child support needs to be paid to Ms. Harrington. And I frankly have a little problem with that.
Well, Your Honor, I think the issue here and where perhaps the former wife or her counsel were confused at the hearing was that the court wanted evidence as to how the needs of the children had changed since the final judgment. They presented only evidence of the current needs of the children and didn't present any evidence about the historical needs or final judgment timeframe.
Well,
So
you know, and the thing is, the court may have wanted that, but that had nothing to do with the allegations of the modification petition. The modification petition said there's been a change of circumstances, and that is that whereas the parties previously had equal financial resources and therefore no child support was going to be paid, now they have vastly different financial resources, and that's a substantial change of circumstance. And there should, you know, we should have a modification and have child support paid. Judge didn't address those things.
I think what the court was trying to do was to understand that in the event the income had substantially changed and the facts set forth or the allegations set forth in the supplemental petition were in fact accurate and the child support guideline number was significant, we're still looking at the needs of the children. And that's because we're in a factual scenario of these good fortune type cases. And so I agree that the court didn't start with an analysis of what is the income and then we're deviating to the needs of the children, because the court said, let's talk about whether the needs of the children are unmet or otherwise substantially changed from the final judgment. And if they aren't, we don't have to do the income and the child support guidelines and all of that.
Let me pose a hypothetical. I recognize, you know, we have an extreme case, as you point out. So let me propose an extreme hypothetical. Okay, let's say that during the 50% of the time the children are with Mr. Kemp, they're living in a mansion, and during the other 50% of the time that they're with Miss Harrington, at this point, they're in a trailer park. Is that consistent, excuse me, with the children's needs, that half the time they live in a trailer park, even though the combined income of the parents is like, you know, through the roof?
In that scenario, Your Honor, that would have been presented at this hearing. The former wife.
No, I don't know. What was supposed to be presented at the hearing is what their needs were, not what the parties' relative abilities were to meet those needs.
I believe that the former wife's spreadsheet was very comprehensive. It was over $100,000 per child.
Okay.
And notably, her financial affidavit filed on February 17th of 2021, prior to the hearing, the expenses for the minor children were a little over $4,000. And if you remove the attorney's fees and payments to creditors, her total expenses, including other expenses for the former wife and household, were a little over $12,000.
Okay, but let's come back to my hypothetical, because you're suggesting that so long as he's got the money to pay and pays just voluntarily, I guess, out of his pocket, the court can decline to award child support under the guidelines. And so half the time the children are living in a trailer park, and half the time they're living in a mansion. Are you suggesting that in those circumstances, the judge could say their needs have not changed, and, you know, I'm just going to leave things as they are? Would that make sense?
If their needs had not changed since the final judgment, then under that extreme scenario, I still agree that the court could do that, and it wouldn't be an abuse of discretion. And that's
their need for shelter commensurate with the party's vast income had not changed, and therefore even though it requires that they live in a trailer park half the time, that's okay.
If those were the facts at the time of the agreement, if the circumstances had changed such that the former wife went from a reasonable home at the time of the agreement to a trailer park, then I agree that the court would have to consider.
Well, isn't she alleging that she cannot afford to furnish these children the lifestyle that they are entitled to under the law?
She alleged that,
but the court didn't the court didn't seem to base its ruling on that. The court based its ruling on the children's needs had not changed.
The court based its ruling on the fact that the needs had not changed, but also she said, Judge Pomponio indicated that there were things that were not necessary. I think I get that. Potatoes, but she also referred to, I don't care about bath bombs and all these things that the former wife was requesting, which were inconsistent with her sworn financial affidavit. And a lot of it were I would say 90% of it were things that were either already met, because she had a color coding system where she had said on the spreadsheet, she had highlighted things that were met, partially met, and things that she still wanted. And when you look at the things that she wanted, those are not expenses that would be appropriate under the case law. And I think even Taylor talks about, a $300 baseball bat and a tuxedo are not reasonable needs for children. And the vast majority of what was unmet or partially met falls under those categories. And she wanted replacement items. It wasn't that she didn't have things in her home. She just wanted to replace them. She wanted keepsake trunks for the children. She wanted a new piano.
Let me suggest to you that if this was if guidelines, child support had been awarded in the substantial amount, under that sub 6B, and as the guidelines contemplate, the payment would be made to her, wouldn't she be entitled to spend it on those things if she wished?
She would, yes.
Okay, but she has no ability to do that because she has, according to her allegation, insufficient income because the parties no longer have equal financial abilities.
Right. I think the issue, though, is, Your Honor, as Taylor and even Ferraro suggest, when a parent in the good fortune type cases is able to pay a substantial amount of expenses directly as a component to child support, and Judge Pomponio felt as though the vast majority of those expenses were being covered by the former husband, potentially in excess of what the guidelines would say. And that's why it's important to hone in on the actual needs of the children before we address the incomes, because if it's being met, we are unnecessarily going through a process that is frankly more expensive than what is needed under the circumstances from an attorney's fees perspective and a discovery perspective as well. With regard to the due process issue, Your Honor, there is some discussion in the brief that the scope of the hearing was expanded. And if that is in fact the argument, then I would suggest that the hearing did cover all of the issues that were alleged in the supplemental petition.
Well, then though, I think you're getting into, there were objections to testimony because, the questions were outside that limited scope, which were sustained. And then of course, sometimes the testimony strayed beyond that. It was kind of I'm too old to come up with an alternative to the word mess. But as you read this transcript, it seemed to be all over the place.
I would agree that the approach was unique, but I think that's because of the uniqueness of the facts.
Unique, that's the word I wanted instead of mess.
Or perhaps unstructured.
Unstructured is good.
And I think what the court has to determine is in a case with this set of facts and the good fortune cases, is it appropriate for the court to cut to the chase and go right to the needs of the children? If the guidelines are going to be deviated down to the bona fide needs pursuant to Finley v. Scott, why does the court have to go through a whole series of other analyses and evidence regarding income when we're going to be addressing the needs of the children? And
maybe the problem with it, Ms. Maxwell, frankly, from my perspective, is that there was no relation to the pleadings, because the pleadings didn't have to do with the needs of the children. They had to do with the incomes of the parties and the ability of both parties to participate in furnishing their children a lifestyle. And the notion that if the children's, needs were not so great that to warrant an additional income thrown at them, that can't be a change of circumstance under the law. I have a problem with that.
Well-
These people started off in an equal position to participate in their children's lives, and now they allegedly do not have that ability. And I think that's what the modification petitions were about, were they not?
Well, even if a general pleading for modification of child support is in even reference to child support in general to modify without any specific allegations that this is a good fortune case, the court would still be able to apply the law with regard to deviation to the needs of the children. So the fact that the supplemental petition didn't specifically state that the needs of the children had changed or even reference the needs of the children, that would still be the process under the law that the court would engage in such a case like this. And therefore, Your Honor, the court did get to the right outcome, and the order should be affirmed. Thank you.
Okay. Thank you, Ms. Maxwell. You did well under fire.
Thank you.
Mr. Vaca?
Thank you, Your Honor. Ms. Maxwell just said that the court applied the law, and most respectfully, that's the thing my client begs for, is to have a trial judge consider the facts and apply the law. And it's something that she was absolutely deprived of before this trial judge. Ms. Maxwell keeps talking about the fact this is a good fortune case. There's no evidence in this record besides the financial affidavits that the judge ever reached that conclusion. There's no finding of fact that this is a good fortune case. There's no conclusion of law that this is a good fortune case. There's nothing. There's a dismissal, a verbal motion to dismiss that has been granted. The same, I looked at this case and it is, Your Honor described it as a mess. I looked at it as lazy. Why isn't somebody putting something in writing so that the parties know what they're supposed to do? I'm going to do an ora tennis motion for bifurcation. And I'm going to do an ora tennis motion for bifurcation where I say the only issue that we're going to talk about is the needs of the children. And then when the wife comes to the courthouse, presents evidence of her daughter's needs, and the judge dismisses it because she didn't provide additional evidence beyond needs, which is what the husband's attorney requested. That denies her justice. And we can talk about due process, we can talk about whatever. This judge did not follow the statutory procedure. She did not issue a written ruling that considers all the statutory factors that allows this court to then provide meaningful review of her decision. So unless the court has any questions for me, we would ask that the court reverse this order, remand for a full evidentiary hearing, and allow Ms. Harrington to have a fair day in court.
Okay, thank you, Mr. Vaca. Thank you both. In order to leave our virtual courtroom, you need to click this button on the Zoom screen called Leave, and you'll go off into the ether. And now our next case is Jackman versus Schwartz.